Hi everybody, Jennifer Schaus here, coming to you live from Washington, D.C. today. And thanks for joining us in our monthly GovCon Live Q&A Cafe. This series runs the second Friday of every month, which usually will last about an hour and a half based on the questions that you guys submit to us. We've got 4 great experts today that are going to present some content. They're going to answer some questions, then they'll take your live questions. So throughout the presentation, you can type in your question on the right-hand side in the question button. I will read them off in the order that they come in, and they are anonymous, so don't worry, I'm not going to read your name. There's nothing to be embarrassed about. Ask these guys the questions because they've got the answers. Everything is recorded, and you can find the recording today from the same registration link that you used to sign up. The PowerPoint, I believe, is already posted on our slideshare.net site. And that's a free site. Today we're obviously covering set-asides. Next month on the second Friday in November, we'll cover pricing in government contracts. And then in December, mergers and acquisitions. So our pricing experts are Marsha Lindquist, Tracy Sheps, Jeff Shapiro, and Michael Gallo. And then we close out the year, Friday, December 10th, with Shirley, Joshua, Kate, and Brad covering mergers and acquisitions. A little bit about us before we dig in. We do provide professional services for federal contractors that are selling anything from products, services to software. We help them with the market analysis, proposal writing, GSA schedules, and some of the other services that you see here listed. You can certainly find more information about us, as well as over 450 webinars on our YouTube channel. You can find those on our website as well. We want to thank our sponsors today. First up is the Virginia PTAC, the Procurement Technical Assistance Center. They offer one-on-one training and counseling, mentorship, and we've got Anna Ehrman as one of our speakers today who used to run the Virginia PTAC. So again, we want to thank them for their support. We also want to thank the Greater Reston Chamber of Commerce. They've got a great GovCon council, and they have a meeting the third Tuesday of every month. I believe those might be in person now. I'm not 100% positive, but you can contact Alicia Field at the email address shown there on your screen. It's aliciaf@restonchamber.org. She can give you more information. You can also jump on their website for additional details. Crown Castle is another sponsor today, and we want to thank them for their support. They're an IT provider selling to both the government as well as federal contractors. Your contact there is Peter O'Brien, and his email address is on your lower right-hand corner of your screen. C3 Integrated Solutions, they've also been a great sponsor and newsletter advertiser with us for, I'd say, a good bulk of the year. They do provide CMMC services. Their contact information is in the lower right-hand corner of your screen. Last up is WorkPlan. They're an ERP provider for government contractors and can help you with anything from contract management, incurred cost submissions, and more. Your contact there is Anita, and her phone number and email address are in your lower right-hand corner. Okay, so let's dig into today's topic, which is set-asides. I think a very important and interesting topic for all government contractors, regardless of your size. We want to thank everybody who has joined us today, including our speakers. We've got Anna Ehrman from the OSDBU, which is the Office of Small and Disadvantaged Business Utilization from Department of State, a longtime friend and colleague, so thanks, Anna, for joining us. We've also got Sai Alba over at Polaro Mazza, with a new logo. So Sai, thanks so much for joining us. Eric Coffey down in southern sunny Florida from GovCon Giants. Great program that he has. So thanks, Eric, for joining us. Last but not least, Tim Furran from the GovCon Law Group. So we've got some great speakers, and we're going to go ahead and start with Anna. So the floor is all yours, Anna.
Thank you, Jennifer, for hosting this event and providing some information and education on set-asides. And I appreciate the panel being here and giving you all sides of this particular complicated GovCon story. So I would like to start by giving you a snapshot of the status of small business set-asides within federal procurement. So what you see here is a table of the current goals, our achievement, as a federal government achievement of those goals, and then what to expect in the future. So for over a decade, the federal small business goal overall has been 23%. So that means 23% of all dollars that are contracted out by US federal agencies must be awarded to small business prime contractors. In addition to that, there are 4 socioeconomic categories that government-wide could receive set-asides, or that contracts could be set aside for. And there are some additional set-aside categories that are specific to several departments. For example, within the Department of Veterans Affairs, they have a veteran-owned business set-aside. Within the Department of Interior, they have programs for Indian-owned businesses. But overall, the government has a goal of 23%. Each department has a slightly different goal that they negotiate with the SBA every year, so that as a sum total, we would end up with at least meeting or exceeding that 23%. The last full fiscal year that we have the numbers for is FY20, and the federal government actually achieved 26% of small business dollars, which means exceeded the goal by 3%. With the socioeconomic categories, again, those women-owned small business, 8A, service-disabled veteran-owned small business, and HUBZO businesses, those goals are also set by statute. And the story varies slightly in how federal government achieved those goals. We made 50%, or about 2 of the 4 goals, and then we were slightly missed the other 2. More importantly, what would be useful for small businesses and actually for the government contract industry to know is that there is a proposal as part of the FY22 National Defense Authorization Act, which is currently in Congress, to increase all of those goals across the board. It is part of President Biden's administration priority for equity for underserved communities, specifically Executive Order 13985, which he passed, which he signed on his first day in office, to increase the government-wide equity for underserved communities in all functions of government, procurement being one of them. So if the NDAA passes with the goals that are set currently, we expect that not only the overall small business goal across government will grow, but also the set-aside, the goals for the individual socioeconomic set-asides. For women-owned, service-disabled, veteran-owned, and HUBZO will increase somewhat, and then for 8A, those goals will increase dramatically, so from 5% to 15% over the next 3 years. Next slide, please. So what I want to highlight and what I want to explain a little bit is kind of the misconception that the only way that small businesses could win work at federal agencies is through the set-aside contract. And what that leads small businesses to do is to only focus on existing small business set-asides and the recompetes for those, or proposing on opportunities that are currently set aside for small businesses. However, there are two strategic missteps with that understanding. One is what you see as the small business goals for the department. Those goals get counted for agencies, regardless of how contracts are awarded. So, for example, if a woman-owned small business wins a contract that is not set aside for anything, that's a full and open competition, we still get to count those dollars towards meeting the women-owned small business goal. So there is no disadvantage for government to have small businesses win contracts that are not set asides. Moreover, what we have seen is that the vast majority of small business wins, of small business dollars, are won by companies in opportunities that are not small business set-asides. So if you're only looking at the pieces of the pie that are small business set-asides, that's a 14% piece of the pie that you could be addressing. And there are many strategies for pursuing opportunities, for responding to sources sought and RFIs to encourage and provide evidence for the government to set things aside. But overall, consider that your government customers are broader than those opportunities that are just in the set-aside portfolio currently. Next, please. One back, there we go. As far as the competition, the availability of bidding opportunities for set-aside contracts, most of the contracts are competed. So if you see my screen, it's a brown, but whatever the red shade that you see, those are competitive opportunities. And across all the socioeconomic categories, the set-asides are competed, 8A being the standout category where many of the programs are sole source, so not competed, but direct awards. And that is because within the 8A program, the preference is that for opportunities under $4.5 million, those are sole sourced to one of the program participants, and anything over $4 million is competed among the 8A program participants. Okay, I'm going to pass the mic now, and we'll save the questions for the end.
Perfect. Well, thanks, Anna, kind of for walking through all of that really good information. And I think it sort of segues nicely into what we're going to be talking about next, which is some of the general programs. And I kind of set it up as compliance keys, compliant risks, and compliance tricks. And so the first piece is sort of the key issues here. And I think it's important to note that what you just saw shows that sort of woman-owned and hubs-owned is lagging behind in a lot of cases, and that 8A is really seeming to be growing or planned to be grown in the future. And the fact that there's a lot of sole source capabilities without a justification or authorization for the 8A program, I think has a lot to do with that, right? It makes it easier. It's not protest proof, but it's pretty close to it. And it just allows the government to get what they need faster without some of the headaches. And that is special. It's only available for the 8A program, where you can take anything and just award it without having to even think about it. Note though too, before I get into some of the specifics, is that the woman-owned program is actually limited to specific NAICS codes and things like that. And so that's why I think the agencies have difficulty sometimes meeting the requirement just through actual set-asides. Now, as Anna noted, the vast majority of dollars they're taking credit for comes through not set-aside work. And I think that probably includes subcontracting. And that's the kind of thing where you could certainly meet those goals if there were more certified companies. And that's where some of these actual certifications come into play. So it's important to note that for the service-disabled veteran-owned small business program, that you don't need, as of right now, you don't need an actual certification. It's all self-certification. So if you're a small business and you meet the rules, you have 51% ownership and control by a service-disabled veteran, and that can include an individual that has a 0% disability but still has the letter from the VA, then that person or persons, it can be split, can control and own that 51%, and therefore you could qualify as a service-disabled veteran-owned small business. That's today. That is going to change. So there's been proposals and through acts of Congress to change this so that the service-disabled veteran-owned small business program for the government writ large would actually require a certification similar to 8A and HubZone, and actually now woman-owned, which I'll get into in a second too. That's for the broader federal government. As of right now, and for many years, people are probably thinking, well, service-disabled vet has had certifications for years. I had to go through CVE. That's true, but that's only for work through the VA. That program only applied to the VA. It did not apply to the broader federal government. And in fact, there were a number of bid protests and things challenging other agencies who attempted to require CBE certification to qualify, as I think they did it just to make it easier so they didn't have to deal with size protests and challenges, status challenges more specifically. Well, but that was never supposed to be the case. So for the VA, there's always been this certification. For the rest of the federal government, there wasn't. Then last year, I think it was last year, there was a consolidation so that the rules for the VA and SBA were consolidated under SBA, but there were still the two programs. So you still had to get certified in CBE to do VA work, and you did not have to do that for the rest of the federal government. Well, now, likely next year is my guess, sometime in 2022, maybe towards the end, we might see some proposed rules so that they would consolidate the programs. The whole CVE certification thing will go away. The VA program will no longer exist, and it will just fall under SBA, but it will be a certification program. So you will no longer be able to self-certify as a service-disabled veteran-owned small business. And that's important if you're thinking about it, or if you're looking at your pipeline and you see new work coming up. It's something that you're going to have to pay attention to and be prepared to be certified. Like my guess is in the next 2-3 years, you're going to have a certification. And the reason I push it out a little further is if you look at the WSB program, sort of skipping to that one, that also used to be a self-certification program. They allowed third-party certifiers to look at a woman-owned small business and certify them, certify in quotes, but you didn't have to have it. That has also changed. And as of right now, I think it changed last year. As of right now, there's a grace period so that you don't have to be certified to bid on work so long as your paperwork is on file and you've applied for that certification. But that grace period is ending. And when that grace period's over, you'll have to actually be certified before you submit. I believe for the service-disabled veteran-owned program, there's going to be something similar to that so that people aren't caught off guard or unable to go after recompetes. And it's likely, my guess is it's going to be about a year. So when all these rules go final, so I think the proposed rules will be next year, the final rules, maybe 6 months-ish after that, because SBA was given 2 years to get this in place. So maybe sometime in 2023, it will go live. And my guess is that they'll give you till 2024 in order to actually get the full certification. And that's not guaranteed, but I think something like that is going to happen. So there will be a grace period. The other thing to know is that when you're talking about 8A and EDWSB, those have always been very regulated. As anyone knows who's worked with 8A companies or gone after 8A work, there's a rigorous sort of process there. You have to meet certain, for 8A, certain socioeconomic categories. So if you make more than $350,000 a year, average over the past 3 years, you're not eligible. If you have a net worth of more than $750,000, excluding your house, your business, and qualified retirement accounts, you're also not eligible. Those rules are sort of the same now between the EDWSB program and the 8A program, whereas they used to have different numbers for each of them. In fact, the EDWSB program was higher. The numbers I just quoted have sort of always been true for EDWSB, and now that's also true for 8A. So they increased it, the total income from 250 to 350, and the net worth also increased from 250 to 750. So it's been pretty significant increases there and made it a little easier to get in the program. The other thing with 8A to note is it's a 9-year program, and after that you graduate. And once you graduate, that's it. You don't get another bite at the apple, whereas the other programs can go on indefinitely. And lastly, when you're talking about the hub zone, I find that to be the most confusing. A lot of clients bring it up, and because there's all these different rules. Your principal office has to be in a hub zone, which is where most of your people perform their work on a day-to-day basis. And also 35% of your total employees, not just out of that office, but all your employees have to reside in a hub zone. And they've made additional rules recently, last year, maybe, about a year ago, in order to allow you to get grandfathered in if someone lived in a hub zone and then moved out for more of a period of time. But you have to actually get certified, and you have to submit an application, and SBA reviews it, and once you're certified, you're good for essentially a 3-year period, but you have to go get certification or re-up it like every year. And that's where you have to actually just put in information every year. So it's the same type of program as what WSB is now, where you have to be certified, 8A, EDWSB, where you also have to be certified, and where SDVOSB is going. And what I think is interesting here is that there was a big push, 10 years ago or so, that all these programs should be self-certified, and it should be policed by competitors through the size protest process. And I think there's been a lot of scrutiny put on SBA to really push them to make these things certified so that there's more accountability, and that's definitely where things are going. Also, when you get into any of these programs, you have to comply at the time you submit your proposal. So, and you all have to be small. I get that question a lot too, like, well, can I be veteran owned or service able veteran owned and not be a small business? No. All of these are small business programs, so you have to be small first and then qualify second with all the other secondary requirements. And that's the date and time you submit your initial proposal with price. So I had a recent case where someone, they knew they were going to size out on October 1st, and they submitted the proposal on September 29th. The CO gave them a hard time, filed a protest against them because they looked them up in SAM and saw they were large on like 2 days, couple days ago. And we pushed back on them and said, no, that's not the way this works. You have to look at the time when we submitted the proposal, even if the proposals were due October 4th. If we submitted on September 29th, that's the date. Even if it was September 29th or September 30th, whatever the last day, at 11:59, and that's when it was sent, that's the day. It's not the next day. And it's important to note that, so that if you come up on a big procurement that's due even in a few weeks and you want to submit early to lock in that date, then if there's any FPRs or other issues that come up later, that doesn't matter. Your certification is locked in at the earlier date, unless there's some recertification event that occurs. Next slide. Okay, so that's sort of the overview. Now we're getting into small business compliance risks. I think there's a couple things that I see most often. First, when you're talking about False Claim Act issues and investigations, and the few we have going on right now, all of them that are small business related, at least, all of them have some limitations on the subcontracting component, where the DOJ is claiming, or the IG office in some cases at the beginning, are claiming that there was a violation. And when you're dealing with a prime sub, that means, depending on the industry, it's either 15, 25, or 50% of the total cost of the contract has to go to the prime contractor. 15 is for general construction and excludes materials. So if it's $1 million contract and 500,000 in materials, you take the materials out and you calculate just based on the 500,000. Same for specialty construction, but it's a 25% limit. And then for services, it's 50% of the total cost of the contract, not just labor anymore. And there are certain ODCs that you can take out if the product's not available from a small business, but that, or the ODC is available. A good example in the reg is airline travel. The issue though there is that it's not every ODC. it's ODCs that are not available from a small business. So you need something in your files to justify the determination you've made in that regard. And then if you're doing manufacturing work, it's 50% of the cost of the manufacturing. Or if you're a non-manufacturer, you have to follow the non-manufacturer rule, which is a whole other set of rules that you need to deal with. Mainly, you have to be in that business. You have to take ownership or possession of the product in a manner consistent with industry practice, not and ownership. So it's possession or ownership. So you can take it in your warehouse but not actually own it, or you can do something like drop shipping where you own it in transit. And the main thing is that you have to provide the end product of a small business unless there's a waiver. So just be aware of those issues. Joint ventures have internal and external performance of work requirements. So the JV itself, all members have to meet those rules I just discussed. But then internally, the qualified members of the joint venture have to do at least 40% of whatever the joint venture is doing. So if it's a service contract and you have two members, one's qualified, one's not, the JV, meaning both members combined, have to hit the 50%, and the qualified member has to do 40% of that 50%. If both parties are combined are doing all of the work and there's no subcontractors, then you have to do, the qualified member has to do 40% of the entire contract. That's what makes this difficult for mainly construction. I see this be a huge problem because it's not 40% of the 15%. It's 40% of whatever everyone's doing. And even though this isn't in the reg, I've seen the Department of Justice try to roll subcontractors up and into non-qualified JV members. So if the subs are under a non-qualified member, just note that if you're investigated, they might roll that up and then consider that work to be inside the JV, even though it's by a sub. And that could throw off your 40% split. And you can push back on that, but these investigations are very time consuming and it's just a pain. So if you can avoid even getting there, I would highly recommend that. So just note that the JV rules are more complicated, and depending on your circumstances, it's important to understand the distinction and how it works. Lastly, in this area are GSA CTAs, and they're their own animal. Interesting note, there's no law or regulation that governs a GSA CTA. They're pretty much made up by GSA. And because of that, SBA has sort of refused to issue rules or regulations governing how the rules are supposed to work for a CTA. If you take the guidance that GSA puts out literally, everyone is a prime contractor because everyone has their own GSA schedule. Really, these CTAs are only for GSA schedules so that every member has their own schedule. The government technically buys directly from that schedule. So thinking of it that way, everybody's a prime, so everybody should probably have to be qualified. So if it's an 8A set aside on a GSA schedule and you form a CTA, all members of that CTA should be 8A companies if you take it literally. I know it's not done that way, and because there's no rules, it's kind of the Wild West right now of federal contracting, and I haven't seen issues either. I can't say I've seen issues on the False Claim Act front or anything dealing with them. So just be aware of that right now there's not a lot of rules and it can be somewhat risky depending on how you're playing it. Next, recertification is something that comes up all the time too, and understanding that if you merge with another company or if you are acquired and do not merge, either one of those things triggers recertification on your work and the buyer's work. Same thing if you buy a contract and it gets novated, so you buy assets that include a contract and it's novated to the buyer has to recertify their size and status on that contract, not all the rest of their contracts. And the seller doesn't have to recertify on anything because there's nothing changing hands in that regard. So if you do a merger or acquisition, it's more difficult because then you trigger recertification on both sides, and you trigger it for all the contracts that you have, including, so if you're a small business for years and you just sized out in, just say January, and you buy a contract January 2nd. Well, if you're not small anymore and you buy another company, you have to recertify on all your own contracts, all your legacy work that you have. And depending on the terms of those contracts, you could get removed. So you have to think about these issues and the impacts before you do it. Also, if you buy a contract or you have a contract that was awarded, maybe bid after May 25th, 2018, and it's an IDIQ, the recertification impact after that point also means that you can no longer bid new work under that IDIQ, rendering it essentially worthless. So just be aware of that as well, and that date. Also, now after November, if you do an acquisition and the award of the contract that you're bidding on for some open procurement occurs less than 180 days after the merger closes, and you can't recertify as small, you're no longer eligible, and you cannot get that award. If it's after 180 days, then you can get the award, but the agency can no longer take small business credit for the work that you do and the things that you win off of it. So agencies might take that into account. Next slide. All right, and lastly, just a couple tricks kind of to throw out there. Because you can no longer sell a division and back out revenues, a few years ago, this was something people were trying to kind of push the boundaries to say, well, if you had a division in your company and it was sufficiently separate, it had maybe its own management, its own employees, a separate line of business, and it was its own cognizable business unit, you could try to sell it. And it worked a few times before the case went to OHA, and I kind of knew it was going to go away at that point. But people used to try to sell these divisions and back out the revenue, and it worked because it wasn't a separate legal entity, it was just a division. Well, SBA clarified the rules and said that's no longer possible. So now it essentially has to be a separate legal entity, a separate subsidiary. And it's important to note that you can have a subsidiary, let's say you're an 8A company. You can have a wholly owned subsidiary as an 8A company, and that separate subsidiary can qualify as HubZone or just a vanilla small business. And you could then bid work through that subsidiary as a HubZone or as a small business. You could not have a subsidiary that's SDVOSB, 8A, woman-owned, EDWSB, because the requirements there require the individual who's eligible to have direct ownership, and ownership through another company is indirect, not direct. But if you wanted to start moving maybe some small business work down to a subsidiary, you could do that. And then let's say you grow large in a few years, you can then hive off that subsidiary and sell it to somebody. And all the revenues that were generated from that subsidiary going back to the beginning of time go to the buyer and fall off of your books. So it could be a way to stay small longer. The issue though is that there's certain rules about past performance and experience of affiliated entities that you need to pay attention to, and just take a look at the RFPs you want to bid on and the agencies and see if they try to restrict it. It might be protestable if they're restricting it, but it can be more of a headache. And you just have to make sure that there's some sort of meaningful involvement by that subsidiary in the work you're doing, not necessarily as a subcontractor, but by providing, reach back support or employees or SMEs, financing, something like that. So you're running the organization as almost like a larger entity as a single whole. It's something that can really help you to think long term and become small if you need to flip to that later, if you find yourself unable to win full and open work and things of that nature. So it just can be really helpful down the line, because I see this come up all the time where people have tried to grow, maybe they've gone into the mid-tier or they've won a couple of huge contracts, but they're finding they're struggling in competing with some of the larger companies out there on the full and open work. How can I become small again? Well, it's not easy anymore because of this division rule where you can't just hive things off. Or people will say, well, I only have so much work in this NAICS code, and so am I small in that NAICS code? No, you look at the entirety of the revenues for the entire company to determine your small business status. and all your affiliates. So by using these sort of techniques, you can have all your different businesses and all your work in different places, and then allow you to throw off pieces here and there. It also works, by the way, if, let's say, work ends on a particular subsidiary and it's just dissolved, that revenue also goes away. So you don't have to sell it. But again, it has to be a separate legal entity, subsidiary, or affiliate. You could also have a couple businesses that you own in certain cases. 8A, really not, but SDVOSB, WSB, or HubZone or small business. HubZone and small business, you can have as many as you want because the certification is not contingent upon the individual. SDVOSB, I've seen some that have maybe a couple. I think the most have 3 businesses. In theory, they could qualify, but once you get more than one, they're going to look harder to make sure you're really controlling it. But if it's a subsidiary underneath the one company and it's wholly owned by your SDVOSB, your WSB, or your 8A, that's fine. And it's note, if you're thinking about the 8A program, there's a requirement that you have full-time commitment, but work done for a wholly owned subsidiary is still considered work for your 8A. So again, that allows you to have wholly owned subsidiaries. And it's just a good thing to note, again, as you're moving forward and looking to comply in the future. So that's it. I will hand it off now.
All right. Thank you so much, Cy. Thank you, Anna. Thank you, Jennifer. My name is Eric Coffey. I'm probably the least known person on the panel today. I am the founder, the host of the GovCon Giants podcast. I've had the pleasure of interviewing hundreds of small businesses, ranking from just starting out and winning their first and second, third contract, to winning their first $1 million contract, to winning multi-million-dollar contracts, to being on the Inc. 500, Washington 100. And so my experiences come from actually doing contracts as a contractor for 10 years in the federal arena, and then also interviewing contractors themselves who actually do this day in and day out. So I come from a different take, a different standpoint on set-asides, having worked in the field with contractors and knowing some of the challenges, the struggles that they go to, and specifically new entities, companies coming into this industry that maybe your business is really successful in the commercial sector, and then you're new to government contracting. And so having that experience is what I want to share today, because I see so oftentimes that you have, for example, we're working with a company now, you do about $10 million, and they want to come in and say, okay, well, what set-asides do I qualify for? Or how do I start doing work in the federal arena? And those are the issues that I think a lot of people are not looking at, because besides what do you qualify for in terms of the set-asides and being eligible, how do you actually get this stuff done? Because from my experiences, getting the work is the easy part. Fulfilling the contract, executing, delivering on the mission is where small businesses fail or falter. So, one of the things that the first slide I put up here talks about just having in mind the people in your team and your staff and what things that they should consider. And there's so many facets of doing work with the federal government that I just want people, I want to paint a picture so that you can have it in mind, all of the different moving components when you're doing business, because it's one thing to actually, like Anna said earlier, to do the respond to the source of SOTs, which is a great form of market research, or the RFIs, which is wonderful. But then you've got to maintain your compliance, like Cy was saying over here. And so that's a whole nother aspect of the business. But then it comes to, okay, who's putting these proposals together? Who's handling the inbound calls? Who's actually sitting out there and meeting with the clients? Who's putting together the presentations, the project management side, the legal, the finance, and then translation. And I say translation because the government does speak a different vernacular. So again, who is actually handling, right, communicating what it is that you do to the government and vice versa? Because some of the times, if you're speaking to an Anna out there, like she's an Ostabu, she's not the actual technical expert, right? She is the person that you're going to be meeting with initially to just tell them all the wonderful things that your business does. But when it comes time to present, your technical expertise, she's going to pass you off to a person who's proficient in that. And so you have to have the different entities, the people in place that understand these different roles that you have to play. And I want small business to take that in consideration because, and we'll get into this in one of my future slides. When it comes to like the 8A program, not only do you have to qualify for the program, not only are we talking about set-asides, but when you start to look at sole source work, there's a whole nother way that they bid. When you start doing negotiated work, there's a different set of rules. And so we're going to talk about that in one of my upcoming slides. Next slide, Jennifer. So the 5 things that I've seen from my podcast guests that you must have for small business. Number 1 is strong leadership. One of my guests said to me again, and again, this is something that we hear all the time, which is, right, hire slow, fire fast. They said they've never regretted firing someone from the first time they think about it. When you're out here, and I think that a lot of times, and again, I don't know who's in the audience, but you have to understand that when you're talking to people in the government, their objective is to fulfill the mission. And so that means that, again, maybe in the commercial sector, someone could be non-responsive. Maybe in the commercial sector, you can do things at your own leisure. But when it comes time to working on a federal facility, on a Navy port, on a government installation, it's a totally different ball game. And so they're going to be looking to have someone that they can hold accountable. We've had times where we've had to give them our POC, who was our 24-hour contact in case an event occurred where we had to respond to someone. So that to me is super important. And I think that what I've seen, the differences are you have less room to slack off when it comes time to working with the federal installations. And so again, that's just my experience of talking with people who came from the commercial sector into working in the federal space. Mastermind group. All of my podcast guests who have been successful, from veteran-owned businesses, women-owned businesses, hubs-owned businesses, they're all part of mastermind groups. There's a lot of organizations and associations out there that you can join specifically that are targeting these spaces. I know this particular month, the National 8A Association's having their conference this month. They had one in Alaska the previous month. Michelle Burnett of the Hubs on Council. Get with these groups, because again, it's not enough just to have a set aside. What Sai is talking about and what Anna's talking about with the new rules that are coming out, there are more rules that are coming down, and that they're trying to raise the sole source limits and all these provisions. And so you want to be a part of an organization that understands this, because there's no way that any of us can keep up with all this stuff. So you want to be a part of an organization that understands the rules, knows the rules, and they're advocating on your behalf. Definiteness of purpose. Again, I've had the pleasure of being on YouTube for the last 4 years, over 600 videos that I've posted. I've talked to thousands of small businesses out there. And one thing that I find, and again, I go back to what Sai just said, where someone has 3 different businesses, a lot of people come and say, well, I've got 3 different businesses, so I'm going to try to go after all of this different work. And I say to them, well, yeah, but the government's a little bit different than on the commercial side. So if you are starting off and you want to, for example, let's say one of your businesses is construction, because I heard construction mentioned. If you want to go down that construction route, the people that you need to know, the organization you need to work with, it's a whole different set of people, the names, what their titles are, the positions, than say the IT space. And while maybe in the commercial sector, you can balance or juggle the two, understanding the acronyms, understanding the people, and knowing who the decision makers are, who the influencers are, it's a whole different animal. So I always encourage small businesses to come in with a definition of purpose for what you want to attack first. And then as you start to build out sort of your space and your name in that area, then you can go off into other areas. Understanding federal buyers' rationale, learning from DoD versus non-DoD differences, and there are huge differences. Again, that shows when you're talking to the person on the other end. I can tell you from my personal experience, working with the national parks is a lot easier than working with the Navy, so to say, or NAVFAC. Totally different animals in terms of, even though the same rules may exist, how they enforce it, how they make you to comply is a totally different. So you may get very comfortable in the way that they do things at one agency, and then you try to take that same personality, your charisma, you try to take that same approach with, say, a NAVFAC, and they shut you down. It's a totally different animal. Knowledge to train government staff. So again, I'm sharing in on do's and don'ts. Having staff that understands the government, understands the buying cycles, understands what their motivations are for the personnel that they're dealing with, and how to respond to that person, and how to essentially get them to give you the information that you're looking for so that you can make decisions, so that you can go with your bid, no bid worksheets. Those are the things that I think that are important. Next slide, Jennifer. And then the last thing, I like to put this in there for set-aside negotiation helps, because what I've learned from my experiences, especially in the 8A, when we're negotiating, small businesses don't understand about their overhead, they don't understand their labor rates, they don't understand the profit. And when we're doing a negotiation, the government is asking you all these questions. They are like, they're pounding you. And so you can't just, specifically when we're talking about sole source work, right? Because this is a set-aside conversation. You don't just turn around and say, hey, here's it's $50,000. Here's my price. They go, no. I need a cost breakdown. I want line item pricing. I want to know your subcontractors. I want to know how much they're charging for overhead. I want to know how much they're charging for profit. And so most small businesses that I talk to, if they've never done work for the federal government, they've never done negotiated contracts, they don't know these numbers. And while the legal aspect is wonderful, when it comes time to sit down with someone on the other end and determine whether or not they're going to sole source you that contract, knowing your rates for overhead, knowing your labor rates, knowing your profit, that is viable and critical. One of the things that I've been able to use, and I saw that Jennifer had a webinar before on FAR, FAR 15.4. She actually has a webinar on this. I don't know which one it is, but it goes back. I looked at it. I use this, and I encourage everyone to look at this FAR section, FAR 15, and particularly the 400 section, because some of the things that I've been able to use with my negotiations is where the government can't use profit as a motivator. And so I want to encourage all of my small business people, look at that, because sometimes we believe that we don't have control and the government has control. And so we're not realizing that this is supposed to be a win-win-win for all parties. At least that's what it says. But I think that sometimes as a small business, we feel like we're at a disadvantage because it's the big almighty government. And so there are FAR provisions that are I won't say in your favor, but they can help you have a more successful outcome when you're dealing with the government and you're negotiating your set-aside projects. How to properly label line items. This is really, for me, it's been instrumental in helping me to get my pricing. Sometimes when you don't know government lingo and you don't know what they're used to, how they're used to classifying items that you are trying to provide them, you may classify them based on your actual business experience, but the government's not accustomed to reading it that way. So when you are pricing or negotiating a project and you may list a line item out. So for example, we had a situation where someone listed out that this person was an observer on a project, and the government says, hey, we don't pay for observers. Why would I pay $20,000 for a person to sit there and observe your project? And so I told them, why don't you change it to subject matter expert? And by just changing and reclassifying the name that they called that line item, and the government said, oh, okay, that's a subject matter expert, and they're going to be there to make sure that this item is properly installed, and that what you're asking for in terms of the submission and the submittals on the back end, that it's probably not only installed, but then the government, we have to provide training to the government, and that comes from a sort of subject matter expert, not an installer. And so just knowing how to label items that the government's used to reading and understanding, that makes the difference when you're negotiating contracts. Understanding micro, SAP, and credit card thresholds, again, super important for small businesses, especially when you are talking about set-asides, because what we found is sometimes, particularly now, a lot of the people, the contracting officer representatives, the contracting officers, the people that were around for 20+ years are phasing out, and we've got a lot of new people coming in, a lot of trainees, and they don't understand all of these rules. And I'm sure, Sai, you probably had to train some people on rules for doing procurement, like he mentioned. We found that even in the negotiations, right, they don't always understand what they can and can't do. And so by you understanding the rules and the thresholds, you can help the government person as well with the negotiation side. So knowing the rules for me is super important, and learning them, understanding, because it may just help you have a much more better or successful negotiation. Thank you.
Great. Well, first, I'd like to thank Jennifer and the other panelists for having me. Certainly appreciate it. And this has been very insightful. I've learned a lot. I'm going to kind of cover a potpourri of topics. We're going to start with the SBA size and status protests. We're going to talk about small businesses and the False Claims Act. And then we're going to talk about what's near and dear to my heart, the Small Business Innovative Research Program. So first, what's a size protest? As Anna told us, to be eligible for a contract that's set aside for small businesses, a contractor has to qualify as a small business under that NAICS code. An SBA size protest is a legal challenge to the agency's decision to award that contract based on the awardee's alleged small business size violation. And so sometimes protesters are going to argue that the awardee on its own is just too large. In most cases, what a protester is going to do is they're going to assert that the awardee is affiliated with one or more companies, and together with its affiliates, the awardee exceeds the applicable size standard. So really what it is a challenge to a company or a company and its affiliates size. So who can challenge a company size? Generally, there's 3 different ways that size protests are filed. First, a size protest can be filed by a disappointed offeror. So if a company loses out on the award for reasons that are unrelated to its own size, that company can challenge the awardee's size. Protests filed by a disappointed offeror must be sent to the contracting officer within 5 days from the date that the offeror receives notice of the award. This is always a big issue, and you know, the last size protest that we did, we dealt with the timeliness issue because our client waited longer than the 5 days to contact us. We still filed the size status protest in the hopes that the contracting officer would take it and run with it on their own. Once the protest is filed with the contracting officer then has to forward the protest to the SBA for size determination. The second way that size protests are filed is by the contracting officer, and that's exactly what we tried to do in that particular case that I just mentioned. So if the contracting officer has any reason to doubt the awardee size, they can go ahead and reach out to the SBA and ask for a size determination. The key to this is there's not a 5-day limit. This request can be made at any time, meaning that even if the contract is already being performed, the contracting officer can ask the SBA to do a size determination. In our case, we were unsuccessful, but oftentimes if you reach out to a contracting officer, they'll take the ball and run with it. And then the third way that a size protest is filed is the SBA itself. So like the contracting officer, the SBA can initiate its own size determination really at any time if it has any reason to doubt a company size. So how are size protests filed and what's required? An SBA size protest must be filed with the contracting officer, who's then going to forward it to the SBA for a size determination. Unlike your bid protest at the GAO, there's really no format for a size protest. The key is it has to be in writing, and it's got to contain quote unquote specific evidence to support the claim that the awardee is not a small business. Speculation and mere allegations are insufficient. Bottom line is that the protester has to provide some level of detail to support its claim. In the second most recent protest we did, we ran into this particular problem. Our client suspected that the awardee was large, but it becomes very, very difficult to support those allegations. Although you would be surprised what you can find, as I mentioned, on the internet when you start looking at Dun & Bradstreet and other areas. So you can provide certain evidence, but you've got to be able to support your claim. After the SBA receives a protest, it's going to immediately notify the awardee, and then the awardee is going to be required to respond with an SBA Form 355 and provide certain documents with that response. These documents typically include a company's articles of incorporation, bylaws, tax returns, financial statements, and any documents that really describe a company's relationship with any potential affiliates. The response and the supporting documentation are usually due within 3 business days after the awardee is notified of the protest. So time is kind of the essence. If you expect this is coming, you should probably start compiling your documentation and be prepared to fill out the SBA Form 355. And when you do that, you want to really make the case for why you meet the NAICS code size standard, right? You want to lay out receipts, you want to lay out employees, you want to make the case so that you don't get an adverse ruling. After the SBA receives the information, it's going to evaluate it, and if needed, they'll reach back out for a more detailed response or additional documents from the company. Once all the information is received, the SBA is going to evaluate it, and they're going to make a size determination, which is either going to find that the company is small or large under the applicable NAICS code. This is going to happen within 15 days. So your size protests move very quickly. You have 5 days to file, 3 days to provide the documentation, and then the SBA will make a determination usually within 15 days. You know, can a company appeal an adverse size determination? Yes. After the SBA makes a size determination, an impacted business can file a size appeal to the SBA Office of Hearings and Appeals, which is everybody kind of knows it as OHA. Size appeals must be filed within 15 days of receiving the size determination. So again, a quick turnaround and a quick timeline. Unlike your initial size protest, the size appeal has to include certain information. That's going to be the solicitation number, the contracting officer's name and contact information, the company's name and contact information, and then the factual basis of the appeal to include a legal argument as to why the size determination is in error. Finally, and this step is often missed, is the appeal must include a certificate of service indicating that a copy of the appeal was provided to the following entities. The SBA official who issued a determination, the contracting officer, the business whose size is at issue, any other company or persons who filed protests, and then the SBA's general office. Once the appeal is received, the OHA is going to assign a judge. The judge is going to issue a notice and order setting a closing date for the record, and then if possible, the OHA judge will go ahead and issue a decision within 60 days of the close of record. So the timelines are very quick. To file the size determination, to file the appeal, and to ultimately get the decision back from the OHA judge. So like size protests, you know, companies can also challenge a winning business's socioeconomic status under one of the SBA's contracting programs. The process for filing a status protest is pretty similar to filing a size protest, but there are some key differences and nuances for each program. So I talked a little bit about this in the different rules and regulations, and when you challenge, you know, who qualifies for what program, it just becomes very nuanced, and it's probably beyond the scope of what we're going to talk about today. But the bottom line is that the general process for a status protest is almost the same as the size protest. The timelines are a little bit different. In a negotiated procurement, the contracting officer must receive the protest prior to the close of business on the 5th business day after notification by the contracting officer. And if the procurement's a sealed bid, the contracting officer must receive the protest prior to the close of the 5th business day after bid opening. There was a recent final rule the SBA issued in December of 2019 that closed the loophole for certain status protests. Again, probably beyond the scope of what we're going to talk about here, but I bring it up just to highlight that this is an evolving area where things change pretty quickly. So it's important to talk to folks and stay on top of the different rules. Next slide, please. All right, small businesses and the False Claims Act. So what is the FCA, or the False Claims Act? The False Claims Act, which is also known as the Lincoln Law, is a federal statute that was enacted in 1863 in response to defense contractor fraud during the Civil War. The FCA imposes liability on persons and companies, typically federal contractors, who defraud governmental programs. It's the federal government's primary litigation tool for combating fraud against the government. What's interesting about the False Claims Act is that it includes a key TAM provision, which allows people who are not affiliated with the government to file actions on behalf of the government, and if they're successful, they can receive a portion of the suit between 15 and 30%, depending upon certain factors. So bottom line, if you're doing something that you shouldn't be doing, that there's incentive for contractors and your competitors to police themselves. In June of 2020, the Department of Justice updated the False Claims Act penalties. So it's a range now of $11,665 to $23,331. I don't know how they arose at the numbers. When it came out in 1863, it started at $2,000 was the initial penalties. But bottom line is that the False Claims Act penalties are mandatory for each separate violation of the law. So a single fraudulent scheme can involve thousands of violations and potentially millions of dollars in fines. This has become a hot area for the federal government. In the past year, I've represented 4 different contractors who have False Claims Act issues. 2 of them relate to small businesses. 2 of them were, one of them was product substitution, and another one was a false certification issue. But we recently had a client who ended up paying a significant penalty because of this, about $2.4 million because of a false certification issue. And I'll talk about that a little bit more. Some of the common FCA risk issues for small business contractors. You heard Anna explain that the federal small business procurement goals are set by Congress. They're currently at 23%. They're about to go up to 26%. And then we also have additional goals for certain categories of small businesses. And again, those are going to increase for your 8A from 5% to 15% and so forth. So the SBA, when they administer these programs, to support these goals, they set aside these contracts for small businesses or for particular socioeconomic categories of small businesses. And so contractors who found to have falsely certified compliance with the SBA programs and regulations can be subject to these SBA penalties that I just discussed above, and possibly even suspension or debarment from federal government contracting. Common issues with FCA risks include performance of work requirements, and I think Cy talked a lot about that on the limitations of subcontracting. So these performance of work requirements often require small businesses on a set-aside procurement to do a certain amount of work depending on the contract type at issue. On a set-aside contract that's restricted, it's often illegal for small businesses to subcontract out all of the work to a large subcontractor, or for a large subcontractor not to comply with their small business contracting plan. And you've seen increased enforcement here. Contractors can also face FCA liability for making false certifications to the SBA, representing that it's either 1, a small business, or 2, falls within a certain socioeconomic category. And that was my particular client that I was just talking about a minute ago. They formed a SDVOSB. They went online and they got some standard documents offline to form the corporation. They had 3 owners. Only one of them was an SDVOSB. Bid and got millions of dollars of work through the VA before the CVE came out. And ultimately, when one of the partners left, it became a big issue that we were able to resolve for them. But the government does take the false certifications as to the certain socioeconomic categories very seriously. And then finally, contractors can face FCA liability for certifying compliance with certain SBA program regulations and requirements. Again, this becomes very nuanced as you start getting into the different socioeconomic programs. So is there enforcement beyond the False Claims Act? Absolutely. In addition to liability under the FCA, contractors can face administrative remedies, which can include suspension or debarment. And what that'll ultimately do is prevent a contractor from performing government contracts for a specified period of time. If you're suspended, you'll have an opportunity to present your case to the suspension and debarment official. If you're proposed for a debarment, you'll have the opportunity to do the same thing. But ultimately, if you're debarred, it's almost a death sentence for a contractor. Not only are you going to be debarred from the agency that debars you, that goes out throughout the federal government, and ultimately it'll filter down to the state agencies. In addition to the administrative remedies, there's also contractual remedies that a contractor can face, such as termination for default. That's usually the first thing that the government will try to do. If you go ahead and file a claim under the Contract Disputes Act for any change or additional work, the government will now assert fraud as an affirmative defense in a claim. I've got 2 cases where that's an issue right now, and it becomes whether or not it was material to the government's decision to pay you. And interestingly, the government's now taking a lot of counterclaims under the Contract Disputes Act because of fraud, and we're dealing with a particular issue there. So you've got some criminal liabilities and some civil liability under the False Claims Act. You've got some administrative remedies, and then you've got some contractual remedies. So how do you protect yourself? So it's critically important, and I think you heard this from Eric, that both large and small companies know and understand the rules and regulations that govern small business set-aside procurements, especially the performance of work requirements and the limitations on subcontracting. It's also critically important that companies comply with the rules and regulations after they understand them. And if you're unsure about something, you know, I recommend that you seek counsel, talk to folks like Eric, talk to the PTAC, and you can always certainly reach out to your legal counsel. Next slide, please. All right, the Small Business Innovative Research Program, and this is near and dear to my heart. This is why my partner and I formed our new firm. We're doing a lot of work with tech startups in the defense space through Futures Command and the Defense Innovative Unit through the Air Force down in Texas. We've seen a huge increase in companies who are interested in the SBA program, largely because the government was supposed to be using OTA authorities for these programs. They just haven't programmed the money. And so the Air Force is very good at using SBA funds like OTAs. The Army's a little bit more risk averse. But bottom line, the SBA program is a small business set-aside program that provides grants for small businesses to engage in federal research and development, with ultimately the potential for commercialization either through a different federal executive agency or in the commercial marketplace. And you're seeing a lot of companies who participate in this program will go ahead and get through into phase 3 commercialization, and then they'll be consumed by a larger company, your Northrop Grumman, your General Dynamics, those types of companies. Agencies with a budget greater than $100 million a year are effectively required to set aside 3.2% of their budgets for research and development in the SBA program. So there's currently 11 agencies who exceed that threshold, and they participate in the SBA program, contributing about $3.2 billion in fiscal year 19. So there's a lot of money out there. The two largest contributors are the Department of Defense at $1.8 billion, and then the Department of Health and Human Services at $1.15 billion. Who's eligible to participate in the SBA program? With few exceptions, it's most small businesses who engage in any type of research and development are eligible to participate. To qualify, you have to be organized as a for-profit company in the United States, have 500 or fewer employees, including any affiliates, and then the work must be performed in the United States with a few exceptions. The company must also be at least 50% US owned and independently operated. There are effectively 3 phases of the SBA program. It's gated phases with 3 processes really. And so phase 1, the objective is to, number 1, establish the technical merit, feasibility, and commercial potential of a proposed research and development effort. And 2, they want to determine the quality of performance of the small business awardee prior to spending further federal dollars. SBA phase 1 awards are generally about $50,000 to $250,000, and the period of the award is about 6 months. And ultimately, if you get accepted to the SBA phase 1 program, the deliverable is really a feasibility study or a report. If the government likes what you did in phase 1, you can apply for phase 2. And the objective of phase 2 is to continue the research and development efforts that were initiated in phase 1. Funding is based on, number 1, the results achieved in phase 1, and number 2, the scientific and technical merit and commercial potential of the proposed project in phase 2. Typically, only phase 1 awardees are eligible for phase 2 award, although you see that a little bit, the different agencies, some will go direct to phase 2 and give you a much larger grant. The phase 2 awards are generally about $750,000 for a 2-year period of performance, but they can go anywhere up to about 1.5 million, and there's also opportunities for matching funding. The phase 2 deliverable is a working prototype. And then ultimately, if you get through phase 1 and phase 2, where you really want to go is phase 3. And so the objective of phase 3 is for small businesses to pursue commercialization, right? The SBA program doesn't actually fund phase 3, but most federal agencies that participate in the SBA program it involves follow-on non-SBA funded research and development, or you can go straight to production contracts for the services or products that are intended for use by the U.S. government. The key to the SBA phase 3, and I think the biggest advantage of the program is really the ability to sole source your particular product or services to the government. So if you go through the SBA program, the government really can't use your intellectual property. There's some mandates that effectively say that encourage sole source awards. So if you get a SBA phase 3, you can go straight to sole source, and the period for that lasts about 20 years, assuming the government needs what you're selling that long. There are different award funding amounts. To date, the different SBA programs have awarded about $43 billion to research-intensive American small businesses. There's a cap that's established by statute. And right now, you're looking at about, for a phase 1 award, it's $259,613. Again, I don't know how they arrived at that number. And a phase 2 award, which would include modifications, is up to $1.7 million. And the agencies can do that without seeking SBA approval. So what are the benefits for small business contractors? The SBA program is one of the largest funding sources for early stage companies in the United States. There are a lot of benefits to securing SBA funding. One is it's stable, it's predictable, and it's not a loan. Number 2, and probably of utmost importance to the small business startup companies, is that the capital is non-dilutive, right? And so we see a lot, particularly in the tech ecosystem. Everybody's trying to take a point. Companies don't have a lot of money to start, so the non-dilutive capital is key. Also, the small businesses retain all their intellectual property rights. The government never really wants to own your intellectual property rights. They just want licenses to it. If you get in the SBA program, there are specific intellectual property rights provisions that apply to SBA awards, where the government only has limited rights or restricted rights, and they can't use your information, much like they would if they had funded it otherwise. And then finally, there's a lot of prestige associated with a SBA award, which can help attract more funding from venture capitalists or strategic partners, because you've already demonstrated to the government that you're a viable company. A phase 3 SBA award is particularly beneficial because, again, a company has the right to receive sole source contracts. Companies are exempt from certain SBA size standards for certain procurements. There's no dollar limits on the size of a phase 3 procurement, and then you have that right to that SBA phase 3 mandate, meaning that the SBA firm has a right to be awarded future phase 3 contracts to the greatest extent possible. And so I think when you saw the rollback of Goldwater Nichols, as I say it, and some of the codification of the OTA authorities and how are we going to get to these non-traditional defense contractors, the SBA program is a great opportunity for folks that are out there that are looking to modify or do some kind of R&D on some of their existing systems. So Jennifer, that's all I have, and I think we're a little bit over time, but I think we still have time for questions.
Thank you guys so much. These were great presentations. We are a little short on time, so we're going to run through the speaker questions real quick, and just if you guys can make your answers short, then we can dig into some of the audience questions. So first one goes to you, Anna. How important are set-asides to meeting the agency's goals?
So as I showed in one of the on the pie chart slide, set-asides are not. They're generally not a huge part of the total small business dollar amount. However, a set aside means that for that particular requirement, if it is set aside, that only the companies that are eligible for set aside can bid. So if an agency in particular is having a difficult time meeting its small business requirements, a set aside is a way to ensure that only companies that are small or that fall into that particular socioeconomic category could bid on it. So you're essentially guaranteed to have a winner that fits within a particular requirement.
Great, thank you. And our next question over to you, Sai, is hang on here. Can a similarly situated subcontractor be used to meet the JV's internal performance of work rules?
No, so this was clarified. So when we're talking about this, it's that 40% I was talking about. You can use a similarly situated subcontractor, someone who's the same size and status as your joint venture. So if it's an 8A, that they're an 8A, and they're small under the NAICS code on the subcontract, you can use them to meet the 50% rule, but the internal 40% rule, you cannot use a subcontractor, even if they're similarly situated. That was clarified or changed at the end of last year.
Great, thank you. And then our next question over to you, Eric. What's the common theme that you hear when it comes to set-asides?
Actually, going back, I think that a lot of the people fed up to me. The common thing we hear is set-asides. The the slide that Irma presented made a lot of sense, which is that 80%, 86% of all of the opportunities are actually not set aside. And so, in fact, what small business should be looking at are simplified acquisition, micro purchases, responding and doing their market research in order to win opportunities, as opposed to just focusing on set asides.
Great. Okay. And Tim, over to you. How are SBA size and status protests different from bid protests filed at the GAO?
Sure. Bid protests filed at either with the agency, the GAO, or the Court of Federal Claims are essentially challenges to the government's solicitation, evaluation, or the award of a contract. The timelines are very, very different, but ultimately you're challenging how the government's rationale for making an award, whereas a size protest really just challenges whether the awardee is in fact a small business. It's important though, a protester needs to be careful how it characterizes its protest, or it could face arguments that the protest is really untimely or filed with the wrong agency. There was a case that just came out in June where this happened. So bid protests challenge the rationale, size protests challenge the size and go to SBA.
Great, thank you. And Anna, back to you. How should a set-aside business market itself?
I think, Eric, you had some really good points in that, and I had a meeting with a small business this morning that exemplified it. They had, we have these six things that we can do, and we're an 8A company. All we need is a program manager. Well, program manager for what? The State Department has 90,000 people that we employ worldwide. Well, and it was a difficult conversation because we had to drill down to the specifics. Okay, if your product solves a particular problem, then who is a government agency, bureau, department, office, and what is the purpose of that office, and how do you solve a problem that is related to their mission? I represent the U.S. Department of State. No Foreign Service person got into the Foreign Service so that they could sign requisitions. You're there to help them meet their job. Explain it to them. And like several panelists pointed out, use the contracting rules and your knowledge of the FAR in order to help your customer meet their mission. Walk them through it, make it super easy to deal with you and to meet both of your goals.
Great, thank you. And Sai, can you form a FAR Part 9.601 contractor teaming agreement partnership that is not a prime sub relationship or a JV?
Yeah, so this is something that kept coming up with COSP4 and also coming up, I think, with Polaris. The way, if you look at the reg, it says that there's two types, right? It's a partnership or joint venture, and then the second one is a prime contractor subcontractor relationship. And a lot of people kept coming up saying, well, it's partnership or joint venture, not and or not slash. So therefore, they're two different things. And I would caution people who are small businesses that it doesn't matter just what the FAR says, right? SBA has a piece of this puzzle. And SBA's rules, they have rules for affiliation and how to comply and be a small business for prime contractors with subcontractors, and they have rules for joint ventures. That's it. So if you're forming a partnership, I see that more as a corporate form, like it's like a partnership, LLC, corporation, as opposed to some different type of entity that's a CTA. If you're a large business, I think you can get away with more because you can kind of do whatever you want. The FAR 9601 is really just a guidepost. But if you're a small business, I think if you're size protested and you're trying to split the difference and not be a JV and not be a prime sub, you're going to confuse SBA, and that can lead to problems. Or they'll just say you're a joint venture and you didn't have a joint venture agreement that meets the rules. If you're 8A woman-owned, serviceable vet, something like that, and then you could lose the contract. So I would say be careful.
Great, thanks. And Eric, back to you. Why do small businesses struggle to find set-aside work?
So one of the things that I would say to that is my podcast guests, there's a common theme that I find with them, the ones that are successful. And they all participate in government training programs. So like SBA Emerging Leaders, the VIP Network, Goldman Sachs, all of them participate in these programs. Even if you believe that your company is strong and you know how to run your business, again, learning the rules of federal procurement is a different animal. And being in a program where they teach you those rules that are already put on by the government, the same people who create the rules, I think has helped tremendously in my small businesses, podcast guests, finding project set aside work and understanding the FAR.
Great, thanks. And Tim, last question before we go to audience. How can a small business contractor find opportunities in the SBIR program?
Yeah, so there's 11 different agencies that participate, and each agency has different proposal and application submission windows. So DoD accepts proposals. Most DoD agencies anyhow accept proposals 3 times a year. The easiest way to find opportunities is to go to www.sbir.gov, where you can find the different opportunities and award information for each agency. You can also go to agency-specific sites. If you Google Army and SBIRS, the Army Application Laboratory will come up. And finally, you can reach out to us, and we can certainly help narrow your search or provide links and information where you can find the opportunities.
Super, thank you. And if you guys have questions in the audience, go ahead and type them in on the right-hand side, which is where you'll find the control panel. There's a section there called questions. They're anonymous, so I'm not going to read off your name, but let me read this first one here that came in. Recently, USAID announced a class deviation for exceptions to limitation on subcontracting requirements for small business set-asides. The deviation excludes work performed outside of the U.S. The deviation does not specify how this should be applied to hybrid contracts, subcontracts, which are performed both in and outside of the U.S. Is there anywhere that this is clarified? For example, if I have a sub whose headquarters in D.C., but also employs staff overseas, do I only exclude the overseas staff? And maybe one of the attorneys want to jump in on this.
I'll go, I guess, and Tim, you can jump in too. But the way I've always understood, this is an offshoot of the general rule that work substantially performed overseas or majority performed overseas, or then the FAR, Part 19, the Small Business Act doesn't apply. So I don't think the intention is for if you just hire a bunch of people in a foreign country to do work, let's say it's like call center work or something, and you have a bunch of people in a foreign country that the calls are being routed to, that's not work that's overseas. But if you're actually doing work that's overseas, I do think it's the work that's going on and is necessarily going on overseas, that money or those dollars for those people, I think that's what this is intended to do, is exclude that, and then you only count the remainder of the dollars. That's my understanding, but Tim, I don't know if you wanted to.
No, I absolutely agree with you, Cy, and I think that you made a good point early on when you started talking about what direct costs you could back out of the limitations on subcontracting and some of these pieces. So I think this is probably a very fact-specific question, and I would hesitate to give anything other than the general advice that Cy gave without talking to somebody or looking at the facts so that we could get you the right answer.
Great, thanks. And then the next question, how long is the process of getting certified as a woman-owned business 8A?
The 8A program, I mean, I don't know if people have been, their experiences have been different, but I'd say it probably takes about 6 months, 6 to 9 months to get your 8A certification, somewhere in that range, in my experience. I think woman-owned is faster, but because of the rule, I haven't been paying close attention because it hasn't really mattered as much. As long as your paperwork's in, it'll probably get more important next year.
Great. And the next question is, go ahead.
Sorry, just a little bit of clarification. Women-owned and 8A are 2 separate certifications, so it's not one application for both. So just be careful.
Great, thank you. I just established my small business in Washington, D.C. as Facilities Support Services, NAICS code 561219, no certification. My question is, where do I need to start looking for jobs, meaning from state or federal contracts?
Look at past awards. First of all, go to the DCPTAC and they could assist. They have training and they have counseling. But the question is, who manages facilities that needs contractor assistance for that? Off the top of my head, based on 15 years of market research experience, GSA, Department of Interior, and Department of the Army. There's some other ones, but that's probably going to be the big ones. And look for smaller opportunities and look for subcontracting within those major categories.
Great. Super. Okay. The next question is, we are an early stage company that has a unique technology which improves on current methods for protecting IT network infrastructure. We are trying to work with 8A and women-owned small businesses, but haven't gotten sole sourced. How does one position oneself for sole sourcing? Our initial federal customers and references are impeccable, but they have all been word of mouth.
Yes, so if you're a company, and I don't know a whole lot about what you're doing, but if you're making improvements to existing technologies, you would certainly be eligible to submit an application or a proposal for a SBA award, which is going to be your best bet to get sole source because of all the things that we talked about with regards to the program. I'd certainly be happy to talk to you and explore different opportunities. We have a lot of companies who have existing technology who apply to the program to further develop that technology, particularly in the areas that you're talking about with cybersecurity and some of those things.
Great. Okay. I do packing. I specialize in military standard 2073 and labeling standard 129. I just applied for 8A, self-certified women-owned small business, economically disadvantaged women-owned small business. My struggle is finding opportunities. We worked with a prime contractor for 5 years. They just let us go due to COVID. Eric or Anna or anybody, any tips on marketing and business development that you haven't already covered?
No, I mean, Anna said it, again, do the market research. I know packaging and crating. You've got places like the munition centers that do packaging and crating. But again, I don't like to give people the answers. I'd rather them learn where to do the research from. So I would say, again, start off at usaspending.gov or fpds.gov. Those are two great places to begin your market research. I always tell people I let the research dictate where I'm headed and not actually looking for opportunities. So again, packaging, crating, find out whatever the PSC code or respective NAAQS codes are, and then start doing your homework. And all of that information is free, it's available. And like Anna said, you can, again, start beginning at the PTAC level. They'll probably tell you a lot of the same stuff. But if you wanted to go from this call to actually doing something, pull up those two websites, type in the PSC or respective NAICS code, and you'll see all of the places down to the office where they're actually issuing contracts for those services.
And go back, this is a cautionary tale for a subcontractor. Know your contract and start building a relationship with the actual government customer, because you were there, you were performing. If you even know the contract number, you could start by identifying that customer, and that'll help you with market research.
With the caveat that your subcontract probably limits your ability to deal directly with the government. So just be careful about that.
All right, we got 3 questions in 2 minutes here. So let's dig in. Can you go deeper into recertification in the multiple award contract context, in particular, how a recertification affects the agency credit claiming versus contract eligibility at the task order level? On the enforcement side, when a company with a MAC doesn't recertify timely, for example, post-merger, is there a lower level of concern if agency credit claiming was the only potential issue? And do you have any insight on how this operates differently under a GSA schedule?
So it's a lot of questions. I mean, basically, if the contract was awarded before May 25th, 2018, and you recertify, it's just credit. If it's after May 25th, 2018, then you're not eligible for new task orders under there. And as far you have to recertify, and if you don't, you could be open to size protests, or Tim was talking about, if you keep bidding on work and you weren't supposed to, that could be a False Claim Act violation. And the penalties are everything Tim said, plus for small business, it's 3 times the value of any contract you won.
Great. And our last question here, I'm just going to read this verbatim, so bear with me. How good the CO gives the 10% price differential for hub zone businesses in open competition. For the VA agency, they always give preference to SDVOSBs. Suggest some ideas on how to convince COs to set aside for hub zone over SDVOSB.
If it's a VA contract, their SDVOSB has to get priority. If it's, I mean, that's what their rules say. So I'm not sure if that's helpful, but it may explain why you're running into difficulties.
Great. Okay, we'll give you guys last minute of fame here. We'll start with Cy. Any last thoughts for 10 or 15 seconds that you want to share?
No, I know there's a lot of issues that small businesses have to deal with. It's probably more complicated sometimes than the large businesses. So thanks for coming, and hopefully this was helpful.
Great, thanks for being on. And Tim, how about you?
Yeah, I would just reiterate what Eric said. Know the rules, learn the rules, know the rules, and follow the rules, and try to stay on top of it because they're ever changing. So thank you again to you, Jennifer, and all the other panelists, and thank you to everybody for attending.
Sure, Eric, and then Anna.
Yeah, no, there's a lot of information out there. There's a lot of actually free information. I always encourage people to start with the free information before you ever pay anybody, an expert. We've got podcasts, we've got webinars like Jennifer puts on. I've got a podcast. There's other podcasts that are put on Skyway Acquisition. So again, there's just a lot of free resources that I think people can explore. I know it's a lot of information to take in, but it's free. And again, you can spend a lot of time on your daily jogs, working out, learning for free at no cost from people who do this day in and day out. And that's what I would encourage everyone to start first before you go out and spend any money.
Super. And Anna, last but not least.
As part of that training and education, build your relationships with other small businesses, with those subject matter experts, with potential teaming partners, and ultimately with agency customers. It's a small market, and we all know each other.
Great. You guys, this was great content. I learned a lot. The questions were great. Appreciate your time and effort that you guys put into the content slides. There's a lot there. If anyone that's on the line has questions, please contact these folks. They are your go-to, obviously, 2 attorneys. We've got somebody from the inside, Anna, and Eric is a great resource for folks that are trying to sell to the federal government, and he's got a ton of resources as well. So thanks to the panelists. It's Friday. Enjoy the weekend. Thanks to the attendees. And again, everybody, really appreciate your time and efforts. So thank you.
Thank you.
Thank you.